Privacy in the Workplace by Kristen Brighty. The definition of employee monitoring is the act of watching and monitoring employees' actions during working hours using employer equipment and property. The increased use of technology in the workplace has created new concerns for both employers and employees in the area of privacy. Use of email and internet can immensely reduce operating costs, but also introduce a new aspect to workplace privacy issues regarding technological surveillance. As noted on the table, different areas of monitoring can include internet connections, email messages, computer files, recordings of employee job performance, telephone conversations, and voicemail messages. Most common use of company surveillance is of internet connections, followed by email messages. Overall, 77.7% of management respondents stated that they engaged in some form of employee surveillance or electronic monitoring. The ethical issue at hand is, does monitoring of employee use of company technology cross the line regarding personal privacy? Both employers and employees are concerned with the ethical implications of constant monitoring. While employers use monitoring devices to keep track of their employees' actions and productivity, their employees feel that too much monitoring is an invasion of their privacy. Employee monitoring has emerged as a necessity and yet as a very controversial issue due to the complexity and widespread use of technology. Employers are concerned with proper employee behavior and code of conduct compliance in relation to their industries and related organizations. While more and more employers are using monitoring devices to check or keep track of their employees' actions, some employees feel that too much monitoring is an invasion of their privacy. Reasons why businesses monitor. First is to guard trade secrets and confidential information. Monitoring electronic communications of employees is one tool for companies to ensure that trade secrets do not escape. Employers are greatly concerned with sensitive and confidential information being sent outside the company to its competitors, vendors, suppliers, and customers, which in turn would harm the company. Also, a reason is ranked highest among concerns of managers is to avoid legal liability and ensure legal compliance. For instance, in harassment and discrimination cases, employers are typically held liable for acts done by their supervisor employees regardless of whether or not the employer was aware of the harassment. An example of this would be if a company were monitoring emails and found an inappropriate joke was being circulated within the firm, they could then prevent potential lawsuits that may arise from this. Also important for many stock trading, banking, insurance, consulting, and accounting firms is to ensure compliance of state and federal laws, such as the SEC, are being adhered to by employees. Non-compliance of these laws could also result in lawsuits and thus an additional liability for companies. Another reason is the excess use of internet for non-job related activities while on the job can be destructive for firms. The cost for employees surfing the internet, also known as cyber loafing, during work hours using company equipment and time can be costly. Other motives for companies to monitor would include prevention of employee theft or espionage, and it can also provide additional information regarding performance review. What is the impact on employees of company monitoring? Well, first, it can create tones of suspicion and hostility in a work environment, creating tension and decreased productivity. And although monitoring can deter cyber loafing, at the same time, it can be counterproductive by causing resentment in employees for being treated like children. In some cases, employees defend cyber loafing because they feel using the internet for personal hobbies is a form of relaxation, and it's a benefit of working for a lower pay. Monitoring may also open up doors for lawsuits if proper notification of monitoring is not taken. Privacy protection laws. The Fourth Amendment states that citizens are protected from unreasonable searches and seizures. However, this applies only to government actions, not actions of private employers. The Electronic Communications Privacy Act includes all forms of digital communications, including private email. The ECPA generally prohibits 1. Unauthorized and intentional interception of wire, oral, and electronic communications during the transmission phase, and 2. unauthorized accessing of electronically stored wired or electronic communications. However, employees are most exempt from ECPA due to either of two statutory exceptions. The first being the service provider exception. This occurs when the employer is actually the provider of services and considered an agent of the ISP who provides the service. The second exception is the consent exception, under which the employer needs only to acquire the implied or express consent of the employee to avoid ECPA violations. If an employee has knowledge of the employer's policy and he or she continues to use the system anyways, they are not protected by the Act. In addition, individual state statutes that strengthen the protection of workers against monitoring have been addressed, but for the most part have failed because of effective corporate lobbying. Also, common law can protect an employee's privacy rights, but are typically shut down because the privacy interest is usually outweighed by countervailing legitimate business interests of the employers. In general, the balance of power in electronic surveillance weighs heavily on the side of employers. So, what can companies do to decrease hostility, respect privacy, and ensure efficiencies in company security? The first step is to clearly state and distribute policies regarding proper technology use in the workplace. Specific notification of what types of monitoring will be used, how frequent monitoring will occur, and what the purpose the employer hopes to accomplish will alleviate anxiety and suspicion amongst employees. Companies can also consider minimizing the amount of surveillance. Some studies have shown high levels of monitoring can lead to tension, anxiety, depression, anger, and fatigue in employees. Instead of increasing employee efficiency and bettering performance, it is actually negatively affecting employees' morale. Hand in hand with minimalizing surveillance could be the implementation of filtering websites. By blocking certain sites that are more likely not affiliated with business-related topics, for instance, MySpace or Facebook, restricting these and the amount of monitoring can be decreased. So back to the question, is it ethical to monitor? Ethically speaking, if monitoring deters misbehavior and produces better results for the employee, the owners, the customers, and other relevant stakeholders, it can then be ethical. Incorporating the appropriate notifications of monitoring policies and procedures can help minimize the negative impacts employees experience due to the monitoring and thus reducing their privacy expectations in the work environment.